This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation.
I have the distinct pleasure of introducing one of the speakers of our morning ethics program, Glenn Barger, and he will introduce his colleagues. Glenn is now a full-time mediator at ADR Services after almost 30 years litigating the same types of cases he now mediates, including bodily injury, professional liability, real estate, business disputes, landlord-tenant, wildfire, labor, and construction matters. He is also a former president of the Association of Defense Counsel of Southern California, where he worked closely with the Consumer Attorneys Association of Los Angeles to create the Joint Civility Conference, and along with the leading judges of the Los Angeles Superior Court, the Settlement Conference Program for the Personally Injured Courts, where a plaintiff and defense attorney jointly conduct settlement conferences at the courthouse. He now brings his experience actually litigating and resolving these cases to the mediation table to help parties resolve their cases. Glenn, passing it to you.
Thanks, Hayward, and thanks for the really nice introduction. Also, I want to thank everyone for attending today. Fortunately, there hasn't been much in the news to take your attention away from our seminar today, so we certainly appreciate your participation. Obviously, we wish that we could be in person together, and we're hopeful we'll get back to that in the near future. But we're also happy that we're able to go forward with something like this online, and we're hopeful that you've been able to continue with your practices, including, of course, mediation sessions online as we go forward with those on a day-to-day basis. Until that time, I would encourage all of you, though, to reach out to today's speakers, either by email, telephone, text, at the end of the day or thereafter, if you have any questions or comments or want to discuss anything that was said today. Because obviously we'd like to grab our favorite beverage with you when the seminar is over, but that's probably not going to be possible. So until then, again, feel free to reach out to any of us. Now it is my pleasure to introduce my co-speakers today. All are truly leaders in the litigation world and frankly, who's who of ABOTA, and are now already off to very successful starts as mediators at ADR. First, it's my pleasure to introduce David Casselman. David enjoyed over 40 years as a highly successful litigator, representing both plaintiffs and defendants in major, hotly contested cases. In 1 year, he secured 2 of the top 10 largest verdicts in California, one representing a plaintiff and the other representing a defendant cross-complainant. Over his career, he tried and won a variety of cases spanning several specialty areas, proving that trial skill is its own area of expertise, and he now brings that to the mediation practice. Along the way, he was elected by his peers to serve as president of the Los Angeles chapter of ABOTA, and then later served as president of CalABOTA, which includes all of the California chapters. But the recognition he would tell you he values most is the Los Angeles chapter's highest honor, which was his selection as their Civility Award winner. Next, it's my pleasure to introduce Jake Courtney. Jake was admitted to the bar in 1988. He spent 32 years trying cases for injured plaintiffs, tried over 40 cases to verdict in both state and federal court. He proudly served as president of the LA chapter of ABOTA in 2018, leading it to be selected the chapter of the year by National ABOTA. He currently sits on the boards of both CalABOTA and National ABOTA. He's a member of the International Society of Barristers. In 2020, he was selected for membership into the International Academy of Trial Lawyers, a very exclusive organization which is limited to 500 fellows and features members from 40 countries. He's tried diverse cases that included mass torts, medical negligence, products liability, business disputes, and bad faith claims. And again, he brings all of that experience to now mediating cases through ADR. Last but certainly not least is Patrick Kelly. Pat's a former president of the California State Bar and the Los Angeles County Bar Associations. And I can say from firsthand knowledge, having seen him at the various bar committees and groups over the years, he's really worked tirelessly for all of us and for our judicial system. For 35 years, he was a member of the executive committee and was the Western Region managing partner and director of litigation for the international law firm of Wilson, Elser, Moskowitz, Edelman, and Dicker. He's a voting member of the California Judicial Council and has been honored by membership in the American Board of Trial Advocates. He's also a fellow at the International Academy of Trial Lawyers and has received numerous awards for his leadership in the legal and professional community. He's currently a mediator and arbitrator with ADR here in Los Angeles. And now my pleasure to turn it over to Pat, who's gonna lead us off with a discussion of the California Professional Rules of Conduct, which went into effect in November of 2018.
Good morning, everyone. Welcome to our seminar. I have the privilege of actually walking you through the nuts and bolts of the new rules of professional conduct. We're going to go very quickly through these, and I'm going to hit the high points of the rules as we go forward this morning. But I want you to remember one thing, if you remember nothing else from this presentation. Attorneys are responsible for knowing and following the rules. It is not a defense to say, I didn't know, I didn't understand. So at the conclusion of this, I'm going to suggest that everyone on this seminar take an hour or two and at least familiarize yourself with the rules themselves, with the resources that I'll give you. What I'm going to do today is give you an overview of the rules that went into effect in 2018, and then focus on some particular rules that might particularly apply to mediation. So let's get started. The rules themselves, the new rules became effective in November 1st, 2018. They were the result of many years of hard work under the chairpersonship of Justice Lee Smalley Edmond. It was a major change in the rules, first one since 1989, and they're located on the California State Bar website, which is calbar.ca.gov. For reasons I'll go into, that is the one website you need to be familiar with. The rules now include a cross-reference table, old to new rules, and a history of the current rules development. There are 69 new rules replacing the 46 old rules. Most of the new rules restate concepts of the old rules, which really are common sense features of the rules that we've all known since we started practice. 27 are entirely new rules, such as a bright line that's been established for sexual conduct with clients. The new rules do not adopt the ABA model rules of professional conduct. In fact, California is the only state not to adopt them, but you can cross-reference the California rules with the ABA rules because of the changing of the numbering system, which corresponds with the ABA rules. Want to make a couple of other preliminary cautionary notes. As I said at the outset, every California attorney is ethically bound to review, adhere to the rules. Failure to comply can result in discipline, including disbarment, disqualification, or a litigated matter for attorney's errors and omissions. We're going to focus on the overview of the rule, but if you have any questions at the conclusion of today's discussion that I'm unable to answer, please drop me an email at pkelly@adrservices.com. I'll be happy to answer them. The rules are organized by 2 preliminary rules followed by 67 rules organized into 8 chapters. And part of the reorganization was create a common sense relationship between the title of the section of the rules and the rules that are contained themselves. Rule number 1 goes through the purpose and function of the rules. I'll spend a little more time on that. Rule number 2 is terminology. And the chapter 1 deals with the lawyer-client relationship. 2 is your duties as a counselor. 3 is your duties as an advocate. 4 is transactions with persons other than clients. 5 is special rules for law firms and associations. 6 is public service. 7 is information about legal services. And finally, chapter 8, perhaps the most important chapter, maintaining integrity of the profession. The purpose of the rules under section 1.0, it's intended to regulate professional conduct through discipline. Remember that, intended to regulate professional conduct through discipline. Willful violation of the rules is a basis for discipline, but does not require an intent to violate the rule. So you must study and know the rules. While violation of the rules doesn't in and of itself give rise to a cause of action, for attorneys' errors and omissions, it can be evidence of a breach of duties. And they do not modify the law of attorneys' errors and omissions, breach of fiduciary duty, and lawyer malpractice. Terminology you should definitely read. It defines the terms that are used within the rules, such as belief, consent, knowingly, reasonable, screened, and substantial. Now to the rules themselves. First, lawyer-client relations, competence. We're going to spend a little time on this, particularly in a virtual environment. Requires lawyers to have the sufficient mental, emotional, and physical ability to handle a case. The safe harbor is if you don't have that ability, you can associate with a lawyer who does. You can also acquire that ability by study and experience. However, you should not be involved in a matter that you don't feel that you have sufficient knowledge, learning, and skill to handle. That's often called dabbling. You're in a case, you're out of a case, you don't really understand what's going on in any depth, but you take it anyway. That is a serious no-no, because remember this, if you're ever sued for malpractice, the claim made against you will be based upon the testimony of an expert who is not dabbling. And you will be held to that standard of care in your handling of the case. So remember that as a hard and fast rule. Let's talk a moment about the effect of technology on all of this, which is particularly applicable to what we deal with in COVID-19, remote depositions, remote mediation, and a few remote trials with more to come. All of these create a challenge to confidentiality. Pennsylvania Bar Association has issued a formal opinion, 2020-300, which kind of has set the standard nationally for what is required of a lawyer with regard to protecting client information in a technological environment. And that provides, it's the duty of the lawyer to understand the obligation and the risks and the benefits of technology and utilize that with that understanding and take reasonable measures to protect the confidentiality of communications. That's a critical rule that all of us need to handle. The analogy is leaving your briefcase in a restaurant by accident and having it recovered by someone who publishes the contents on the front page of the LA Times. Clearly, if that is wrong, no one would dispute that. The same is true of having technology that doesn't have adequate safeguards and securities to avoid hacking and avoid invasion of your client's information. Communications with clients, important rule to remember, 1.4, you have to promptly inform clients of all matters with respect to which informed consent is required. That's worth repeating, with respect to which informed consent is required. You need to advise a client of any limitation on your ability to act on their behalf. And you have to advise them if they ask you to do something that you know will violate the rules. You have to tell them it will, and you won't do it. What is the single most often made complaint against attorneys? Important thing to remember: returning phone calls. Returning phone calls ties into the giving the client information for which their informed consent is required. Confidential information of a client. Here's a code section you need to write down and remember, because it sets forth the standards of duty of an attorney in the community. It's Business and Profession Code section 6068. This particularly at rule 1.6 references section E1, but there are many, many sections. This relates clearly to virtual meetings, mediations, and documents transfers. And important to remember that because a communication is remote, creates no safe harbor with regard to confidentiality being protected. You have to protect it with the same diligence that you would protect documents in your office. And note again, this Pennsylvania Bar Association on legal ethics and professional responsibility opinion that I noted earlier. Working at home or another remote location is under the same obligation as if you were in your office. And a lawyer has a duty not to reveal confidential information and protect it inviolate. The next is conflicts of interest. Here's a new rule that puts forth a two-pronged test to determine whether there is in fact a potential conflict which would trigger a need for informed written consent. Where there's direct adversity to another client in the same or a separate matter, or where there's a significant risk that the representation of the current client will materially limited by the responsibilities you have to another client. In either case, the attorney cannot proceed without informed consent. Here's a good way to look at this. If you're going to learn something from client A, you have to remember that you have to be prepared to tell client B everything client A told you and vice versa. So if you're in a situation where your ability to represent clients is going to be impaired because you may learn something that you have to reveal to yet another firm client who may have an adverse interest, you need to get informed written consent. And if the conflict is significant enough, it may not be waivable. So remember rule 1.7. Sexual relations with clients. This is a new bright line test providing sexual relationships with clients, period, the end. Next, conflicts of interest with current clients. Imputation of conflicts of interest. Important to note that when you're in a law firm, the conflict of another attorney can be imputed to you. There is a knowingly requirement. And also this rule, for the first time in California jurisprudence, recognizes the concepts of ethical screens, which may be effective in limited circumstances to allow you to go forward with representing clients who otherwise would have a conflicting interest. There are many cases that are interpreting this. It's very fact specific. I've listed a few of them here. The National Grange case, First American Title, and Hendrickson. I urge you to read these cases and look up decisions on ethical screens if you have that issue in your practice. Organization as a client. Here's a critical rule that is violated oftentimes in depositions. If we were taking a hand raising, I would ask, when you're representing the general manager of a client in a deposition, who do you represent, and is there a potential for conflicts? Important to remember, you represent the organization that engaged you. And while you may represent that individual for purposes of the deposition, you need to make clear to them, one, that you're representing them in the deposition, but you're not going to be representing them for all purposes. And two, anything they tell you, you have a duty to reveal up the line to the organization. And if they are uncomfortable with that, you either need to continue the deposition or terminate the deposition and arrange for separate representation for that individual party. This particular rule is honored in the breach, I would say, almost more than any other basic organization conflict rule. A lawyer is a neutral third party. I included this simply to point out that mediators are persons who assist two or more persons who are not their clients. Therefore, they are not bound to the same rules in their neutral capacity as they would be were they representing you as a client. However, even if a neutral is acting as a neutral, if they are an attorney, they're going to be bound by the same rules that we're going to talk about in a moment with regard to misrepresentations and truthfulness. Candor towards the tribunal. This replaces old rule 5-200 and prohibits knowingly making a false statement of law or fact to a tribunal. The duty continues to the end of the case, even if your representation terminates before that time, and it's a bright line rule. You cannot make any false statement of law or fact to a tribunal, and if you learn that a statement you made is true, you need to correct that with the tribunal. Rule 4.1, truthfulness in statements to others. This is a critical rule and one that is often discussed in terms of things like puffery in a mediation context. How far can you go in making representations in the context of settlement or a mediation? We've always known that entering a settlement based upon false facts that you know to be false, on which you intended the other party to rely, creates fraud. And fraud creates a settlement that can be undone and has potential consequences. I think all attorneys know that. But the new duty imposes a disciplinary standard beyond what it used to be for misrepresentations to third parties. Counsel may be deceived not only for deceiving, or disciplined not only for deceiving a tribunal or opposing counsel, they may be civilly liable for false statements. Look at Business and Professions Code sections 6106 that also makes counsel subject to discipline for acts of moral turpitude or dishonesty. Communications with unrepresented persons. This is a difficult one because you often have a phone call or interviewing a witness. You need to make clear upfront who you represent and that you don't represent them. It emphasizes a lawyer cannot misrepresent that they are disinterested and must correct that impression if they know or should know that it exists. They cannot seek information they know is privileged or confidential and should not be divulged. Be very cautious on this one because it can haunt you, not only in terms of having had that communication with that individual, often a witness, but can also haunt you at trial if that witness is put on the stand and your conduct is made known to the trier of fact. Rule 4.3. Rule 5.1, this one puts terror in the hearts of all managing attorneys because it defines new rules for lawyers who manage law firms or individual lawyers. Supervising lawyers have a duty to make reasonable efforts to secure compliance with the rules by all that they supervise. Very important for rule, if you're in a supervisory or management capacity, read Rule 5.1 and the cases under it. Responsibilities of subordinate lawyers. To some extent, that supervisory rule is a two-way street. Subordinate lawyers have an independent duty to comply with the rules, and if they believe the senior lawyer's proposed resolution will violate the rules, they have a duty to communicate their disagreement to the lawyer and remove themselves from the case if they cannot come to an understanding with regard to whether or not a rule is being violated. Membership in legal service organizations. I included this because so many of us are involved in pro bono activities where you may, for example, representing a client in a landlord-tenant case, come into opposition with a landlord who's represented by your law firm. If you run into any of these potential conflicts, I urge you to read carefully Rule 6.3 and Rule 6.5 with regard to exceptions to the normal conflict rules in that limited circumstance. Communications concerning a lawyer's services. A special rule under Section 7 that provides false or misleading communications about services or your capabilities is the basis for discipline. Not to mention a legal malpractice suit where you claim that you're an expert and it can be proven that you were not, and the case goes south. The final section we're going to talk about is Section 8, which is misconduct. Rule 8.4 identifies specific instances of misconduct. I'm not going to go through each and every one of them. Engaging in conduct prejudicial to the administration of justice. Remember that one because potentially that loops you into a disciplinary violation for being uncivil in the handling of litigation. And another important one is it's a misconduct to imply an ability to improperly influence a government agency or official, or assist or induce a judge to violate the code of judicial ethics. Prohibited discrimination, I include this, you should read it. It used to be that there had to be a finding that you had engaged in discrimination before or harassment before a disciplinary offense is triggered. This is a new rule that provides that if you've been charged with prohibited discrimination, harassment, or retaliation, you may have a duty to self-report. So I urge you to read carefully Rule 8.4.1. Additional references, I mentioned Business and Profession Code Section 6068, which defines the statutory duties of attorneys. Be very cautious in reading that. It's a lengthy section. You should know precisely what it provides. There's an ethics hotline at the State Bar. You can find that number on the State Bar website. Also on the State Bar website, it will give you a reference to ethical opinions that have been written by the State Bar Ethics Committee. And you can also look at ethics opinions written by your local bar associations. Finally, a comment on civility. Civility has really hit the front page in terms of judges who are starting to apply civility concepts to rulings. Take a look at, for example, Martinez versus O'Hara, where the appellant used derogatory language towards a female trial judge, and the court reported the attorney to the discipline committee for violation of Business and Profession Code 6048B, which respects a duty of an attorney to maintain respect for the judiciary. And there's a new committee started by Justice Brian Callahan, who wrote the Brigantine versus Chow decision, which is also noted on this this program. So unfortunately, we don't have times for questions, but I remind you again, if anyone has any questions, please email them to me, patkelly@adrservices.com. Thank you. And now to Glenn.
Pat, before you go, Pat, before you go, a number of panelists have been asking for copies of your excellent PowerPoint. And I think to the extent that any of us are using PowerPoints, not all of us are, we'd be happy to share them for everyone afterwards.
All right, of course, I'll make those available to ADR services, and anyone who wants a copy of them can obtain it by contacting ADR services. Thank you, David. And with that, I'm going to introduce Glenn Barger, who introduced all of us. And Glenn, I'd like to start with you with a question. Why is it important for attorneys to understand the disclosure requirements or lack thereof, depending on the type of proceeding? And are there differences between what is required depending on whether it is a mediation, settlement, conference in court, or other proceeding? Glenn, take it away.
You need to exit your PowerPoint.
I
There
am.
you go. Thanks.
Great. Thanks, Pat. And thanks for that excellent summary of the new rules. And for anyone who's looking for some light reading, as Pat mentioned, you can go on the State Bar website. And like most rules, it's very clear and concise. The 69 rules is condensed into, I'm not sure how many pages here, but it is easy to print out. There's a PDF on the State Bar website. In answering your question and covering this issue of disclosures, I think choosing a mediator can certainly be one of the most important decisions any attorney makes for each particular case that they handle. Ultimately, most would agree you want someone that has experience with the issues in play, is neutral and impartial to the parties, and of course, ultimately helps close the case fairly and reasonably, or even favorably from your perspective. As a result, the level of disclosures required or lack thereof of required disclosures for neutrals in the voluntary mediation setting is important for attorneys to know and understand. The level of disclosure required, again, if any, varies depending on whether it is a private, outside of court mediation where there's no specific rules, or it involves the selection of a discovery referee, it involves court-ordered mediation conducted by panel mediators, or disclosures required for arbitrators where there are specific rules. I'm personally going to focus on mediation, and I know Pat's going to address some of the disclosures related to arbitration later in the afternoon. The big difference being in arbitration, obviously the arbitrator's typically making binding rulings, whereas in voluntary mediation, it's really the parties that are in control, and we'll talk about that. As of now, the Judicial Council rules only apply to court-ordered mediations conducted by panel mediators. Mediators retained in the private setting do not have formal disclosure requirements to prospective counsel and their clients. I actually mediated a case just a couple of weeks ago for one of my former partners, who I still have, or at least I think I have a close relationship with, where opposing counsel is also someone I've known my entire career and certainly have a very good relationship with him as well. They were both well aware of my relationships with both sides and actually agreed without my knowledge, at least until it was formally set up, to use me as the mediator. Also, having practiced for many years and having been involved in various bar associations like my co-presenters and lots of mediators and judges out there, I've actually gotten to know many of the attorneys, including been adverse to them in the various actions for these attorneys that I now mediate cases with. I developed professional and very good relationships with many of them over the years. And in fact, I actually think far from a detriment or even a concern, I think it's a benefit to have a respectful, civil, professional relationship with a mediator, as it doesn't change the mediator's role as a neutral, but should allow them to have direct, civil, substantive conversations in order to ultimately help achieve a settlement. And that, again, is everyone's goal. This is especially the case if you believe in your case. In fact, I typically went with the mediator the other side recommended if we didn't have one we both liked, because I wanted the other side to trust and ultimately listen to the mediator. With that said, though, there are no formal disclosure requirements, as I've mentioned, for voluntary mediation. The requirements for court-appointed mediators certainly provide a guidepost for voluntary out-of-court mediations, but again, they're not required. In this regard, in contrast to the private mediation setting, panel mediators for courts must maintain impartiality toward all of the participants and make reasonable efforts to keep them informed about matters that reasonably could raise a question about their ability to conduct the proceedings impartially. Matters which could raise questions about a mediator's motives include past, present, and current interests, relationships, and affiliations of a personal, professional, or financial nature, and the existence of the same grounds for disqualification of a judge specified in Code of Civil Procedure Section 170.1. There's also an ongoing duty to disclose issues which may impact impartiality, the typical ones being financial issues and personal relationships. I personally don't think that most mediators would want to touch a case which somehow may directly impact them financially beyond getting paid to mediate the case. Fortunately, having been an attorney for so many years with now an 18 and 21-year-old daughters here in LA, I don't have the burden of significant financial interests in my portfolio. But an obvious example for others would be a mediator who owns a competing business to the business involved in the matter, for example, or a significant financial interest in a party to the litigation. There certainly are examples of parties attempting to undo settlements based upon claimed conflicts of a mediator's interests. But again, at least in my experience, I think most mediators probably err on the side of caution. Another area where there could be disclosure issues for court-appointed mediators, and most likely even in the voluntary mediation, is if one of the parties is a former client and or the mediator was actually involved in the actual litigation as counsel. Importantly, it should be noted that getting regular business from an attorney to a mediation is probably not enough to cause an issue. However, practically speaking, especially with the prevalence of listservs that are out there and the internet, most mediators have been carefully vetted before they're chosen. And I believe most mediators, including myself, would certainly be happy to discuss their experience, relationship with counsel, or other issues before a party who does not know them voluntarily agrees to use them as a mediator. I would suggest picking up the phone and calling a mediator you're considering that you haven't worked with before. I got a call just last week from an attorney and wanting to know my experience with real estate and specifically the car forms and disclosure requirements, and also wanting some information about my relationship or experience with the other attorneys in the case, who actually I didn't know any of them. We had a good discussion and I encouraged them to have the other attorneys give me a call as well. There's no reason you can't have discussions with the mediators in advance of a mediation. In fact, I'd encourage it.
Yeah, Glenn, I think that's a point that many people don't realize. I mean, I think a lot of people think they can't have that first conversation with the mediator until there's been some sort of retention. That conversation, pick up the phone and talk to us, because you may find out that what you thought was an impediment to us mediating your case isn't there at all.
Yeah, that's exactly right, Jake, and I appreciate that. When it comes to disclosures, and most likely why there are no specific disclosure requirements in the private mediation session, it's also important for you to realize that pursuant to Rule of Court 3.857B and H, mediators are not obligated to ensure the substantive fairness of an agreement reached by the parties. In fact, mediators may present settlement options and terms, but it's up to counsel to decide and finalize the settlement terms. I personally may agree to be a scrivener at the end of the mediation, although my handwriting is as dismal at best. But it's up to the attorneys to prevent the specific terms. In fact, as Pat had mentioned, a mediator is not supposed to offer legal advice, but this is obviously a gray area, as mediators do typically discuss legal issues such as liability, damages, procedural issues, even how a jury may view a particular case or witness throughout the mediation process. In fact, my experience is most counsel welcomed it. I welcomed it when I was practicing. I appreciated a mediator who would give me their take on things and presumably was doing it to the other side as well, so that the parties can ultimately make an informed decision and reach a reasonable settlement. I oftentimes tell the parties that we're going to talk about the issues in detail: facts, law, insurance, emotional issues, practical issues, whatever is relevant, so that we can ultimately have the parties get to a settlement. I haven't kept stats, but I'd guess in 9 out of 10, if not more, of my cases, the parties in counsel want my thoughts and comments and want me to give them to the other side. And that's all fine ethically, as long as the mediator remains impartial. Practically speaking, even though a mediator has no obligation to ensure the substantial fairness of an agreement, I know I don't want to embarrass an attorney. I don't think any mediator does. And most importantly, all mediators want to help to get the parties to a settlement that won't fall apart when it's time for the signatures, because an important issue wasn't discussed or agreed upon during the mediation process. Knock on wood, that hasn't happened to me yet. But here I just think it's important that you raise any specific issues you want included in an agreement before it's time for signatures so that they can be discussed and considered. One issue that comes up a lot, typically at the very end of the day, is confidentiality. And then the issue of whether the plaintiff would want, or any of the parties would want, some sort of additional consideration if they want confidentiality to be part of the settlement, as well as the potential tax issues, which has apparently come up out of a Dennis Rodman tax decision. Confidentiality is an example of something I think you need to discuss with the mediator early, and then together you can decide when to raise the issue with the other side. Although you as counsel recognize it, probably important to know for your clients that mediators have the power to persuade and cajole, but not order the parties to do anything. And you can see the SAETA case, S-A-E-T-A, it's 2004, 117, Calap 4th, 261, and Travelers, 2005, 126, Calap 4th, 1131 for discussions on that point. I personally discussed the fact I'm not a judge and can't order anything with the parties up front, and let them know that they're in control today, as opposed to once a judge and a jury take over. One specific. Go ahead, David.
Question that comes up, and I think some of the chat people have looked at this as well, is whether or not you typically recommend that you actually have a settlement agreement written before you leave, even though everybody swears that there's a deal. What's your thought about whether or not they have it in writing, signed?
Look, I'd probably err on the side of caution, and I would hate for a case to fall apart after the parties have left. I think where it's challenging is when it's a multi-party case, and I do a lot of those. I may have 20 parties in a mediation, all in different locations now on Zoom. And I should say the Zoom platform works perfectly well. I've probably done close to 200 mediations already online, whether they're all online or there's some hybrid approach where some people are in person and some people are online. And even there, and probably even more importantly now, and I've seen attorneys do this, especially in the employment matter, in employment matters or in highly emotional matters, they actually bring a settlement agreement with them. And then they fill in the blanks, or even have the blanks typed up and filled in and circulated to everyone. And then I stay online with everyone until it's sent around and circulated and signed so that you get it wrapped up. I'm sure most people are familiar with the ADR short form agreement as well, which all of us have and can email to you at the end of the day. But just get something signed is probably good advice, so that you at least have a binding settlement at the end of the day and no one gets squirrely on you at the end.
I think it's important once you're getting something in writing to make sure that the agreement says that it's effective or intended to be binding, so that the confidentiality rules apply under the evidence code. If you don't say that in a signed agreement, then the confidentiality won't adhere later.
Yeah, and I believe the ADR agreement says that, and I know some counsel have it, and Lucy and the leadership at ADR have been pivoting really quickly during all of this craziness that we're dealing with. And I know they're going to have DocuSign available soon, so that it's easy to have people sign those and make them binding. So you don't have to get a court reporter on the line to put it on the record. Another issue I just wanted to distinguish was discovery referee proceedings. You should be familiar with California Rule of Court 3.904. It states any significant personal or professional relationship the referee has or has had with a party, attorney, or law firm in the current case, including the number and nature of any proceedings in the past 24 months in which the referee has been privately compensated by a party, attorney, law firm, or insurance company in the current case for services, must be disclosed. And it goes into further details. Also, you should be familiar with Canon 6 of the Code of Judicial Ethics related to disclosures of financial issues. Again, it's different than the voluntary mediation process, because the discovery referee will likely be making rulings, which, although not technically binding probably until the court signs off, is making rulings. So there are different requirements. Finally, and then I'll turn it over for some other comments from my co-presenters. But from a practical point of view, as an attorney, I chose mediators that help me close cases. And I think that's the most important role for all mediators. ideally reasonably and even favorably for your client. And so some of the mediators I really liked professionally and had good relationships with over the years, I used as mediators because I felt I could trust them, help me resolve the case. And frankly, I think the other parties did as well. However, I don't believe that means the mediator wasn't acting ethically as a neutral, independent person for all sides in a particular matter. And I think a good mediator works equally well with both sides so that all parties can trust the mediator to help get the case closed, again, hopefully favorably for everyone. So with that, I'd just ask a general question of the panelists. Look, you guys are all extremely accomplished trial lawyers, and you've been involved in settling some of the biggest cases in the state, if not the entire country. And I would guess, or I'm absolutely certain that you have various relationships, probably even some good and even some bad, with counsel and even parties now that you're serving as neutrals at ADR. How do you deal with disclosures and potential conflicts, even in the voluntary mediation setting, including discussing past relationships you may have had with parties in the cases you're mediating? Pat, you want to
Go
jump
ahead, and Pat, go ahead.
Well, I in fact have confronted that issue, and my rule of thumb is clearly I will disclose any relationship I've had to any of the parties or the clients in a case that I'm asked to mediate. That said, I have specifically not handled mediations in at least one case where I was involved in the case when I was a practicing attorney. So I think while you're correct, there's no defined rule on this. I think good judgment is the best safety action you can take.
Yeah, I agree with Pat. Going, you're around a long time and you know a lot of people, and I think one of the common areas that comes up is when Pat was talking about membership in legal organizations, whether it's ABOTA or ISOB, those organizations made up of plaintiffs, lawyers, and defense lawyers, and we've been to events together, we've traveled to conferences together, and I make sure everybody knows that. I don't want there to be a surprise where and I think I can put that aside and remain impartial. But if it comes up late in the mediation, it may undermine the goal that you're trying to achieve. So, if anyone asks, I'm more than happy to share. Not to the formality of an arbitration disclosure, but just ask, and I think that's the best way to get the answers you're looking for.
I agree.
And David, when you were practicing, how did you deal with that issue as far as choosing mediators and finding out their relationship with the parties?
It's interesting because it wasn't really a well-discussed or known fact that mediators don't have the same disclosure requirements as arbitrators, but it is true, and you get automatic disclosures if you're being selected as an arbitrator, and you're required to send that out. And so we would see that routinely in arbitrations. But for mediations, I think I did the same as everybody. I wanted somebody that I felt could relate to me and to my client and to the case. They had the expertise, and also that they would be balanced. I did exactly what you were saying, Glenn, both as a defense and a plaintiff's lawyer. I wanted somebody the other side picked because it was critical to me that the other side would listen to the mediator who's talking to them confidentially when I'm not around, so that they wouldn't say to their client, well, this is the guy that, opposing counsel picked, and, no wonder he says that. So I think it's important to have somebody who both sides respect.
Great. All right. Well, so with that, I think our next topic is puffery. I don't think that's the Seinfeld puffy shirt episode topic. It does remind me of that old lawyer joke of when a lawyer's lips are moving, isn't the lawyer doing some form of puffery, or some other word I think is used. I'll ask Jake, because you're going to take the lead with this. Isn't everything said to a mediator some form of acceptable puffery? And then what are the limitations, if any, as to comments you may make to the mediator or even the other side.
You know, I think it's a word that's very commonly misunderstood. And to some people, puffery is lying. To some people, puffery is exaggeration. Is this puffery? This is about to be the world's greatest presentation on puffery in a mediation setting. I don't know. We got to look at the history. I think it's important that we go back in time and we try and define what the term is, where it came from, understand how it's been interpreted by the court. And then I think the four of us can have a discussion on where we see it in the mediation practice. The term actually goes back to England and to a case in 1892. A lot of people, when they right now are going through this terrible pandemic, have heard a lot about the pandemic of 1918, where millions of people died. 30 years before that, there was another worldwide pandemic. It was an influenza flu that either originated in Russia or Asia. And that flu wiped out 1 million people at a time when there were a lot less people on this planet than there are now. There was a company that came up with a product, and it was what I envision kind of what a neti pot is now. And it was a tube that you put in your nose and you flushed out bugs and germs using carbolic acid, carbolic smoke that was supposed to flush out your system. And you were supposed to use this product for 2 months, 3 times a day. And they ran an ad that said, you know, if you do this and you use this product properly, then if you get the flu, we'll pay you 100 pounds. 100 pounds in England in 1892 was about $11,000 US in present day money. It was a lot of money for a product that cost 5 pence. A woman out there in England used the product as prescribed, and she then got the flu. She turned around and brought a claim, and the defense in that case was to say, are you kidding me? You know, 100 pounds, we would never, you know, that it was just mere puff. And that was where the term was born. The term is interesting because in that case, although it was determined to be puffery, it was a case that ultimately stood for the proposition that a unilateral contract can be formed because there was reliance. And the woman followed the instructions, did everything they said. Turns out the company had put 1,000 pounds into a bank account. And so, you know, with that, it was determined that although they said it was puffery, it wasn't found to be puffery. And in fact, the woman won the case. When we think then of the history of puffery and the development of puffery, we think about advertising. And we think about Nike. It must be the shoes, the Air Jordans. Starbucks, they're a big one. The best coffee for you is the best coffee. At Ford, quality comes first. These are kind of these big grandiose statements about their product being the best product in the world. Most of the case law in this area is in advertising and in securities, stock trades and things of that nature. There's a famous case where Enron was a defendant and Schilling, the CEO of Enron, had made statements about the reliability of the investments. The case I want to talk a little bit about, though, is a case from 2000. It was a Fifth Circuit case involving Papa John's and Pizza Hut. Papa John's was the new kid on the block, company rising in terms of number of stores, and Pizza Hut was the big giant already in the marketplace. And Papa John's started a campaign that was better ingredients, better pizza. And Pizza Hut didn't like that because the inference was that Pizza Hut was using inferior ingredients to make inferior pizza. And there was a lawsuit brought. And it's a really interesting case if anyone is really bored in this time of COVID and you're looking for something to read, because although it was determined to be puffery, it was also determined to be misleading. Because when they used it in a kind of a broader sense in their advertising, they started to point out other things that other competitors were doing. They were using purified water. Pizza Hut was using tap water. And as a result, under the Latham Act, although it was not puffery, it was still determined to be misleading and actionable. And so, I think as we see this evolution, we start to get guidance on what is puffery. The current Ninth Circuit defines puffery as exaggerated ads, blustering, and boasting. As it applies directly to mediation, there's very little case law in California. And so I was able to find some things that, where is it applicable and where do we see it? And there was a case in 1983 called Verizee versus Grand Trunk Warehouse. I won't give you the site because it's not controlling in California, but I think it's interesting. What happened there was a mediation set, and the plaintiff's lawyer filed a brief after meeting with their client, and they set forth their damages and injuries. And then at the mediation, the plaintiff didn't show up. The plaintiff's lawyer maybe wasn't aware what had happened, but assumed that the plaintiff wanted to settle the case and had some consent in theory before the mediation. And the case did in fact settle. It turns out that the plaintiff had died. And that unintentional act, this kind of this puffery, this bravado of going forward of the plaintiff's lawyer, like the plaintiff was in the other room when the plaintiff was not, was a significant fact, because the plaintiff's lawyer, and the kind of the part and parcel of puffery is things that you say and things that you don't say. And in that particular case, when it was determined and found out that the plaintiff had died, the defense lawyer made a motion to set aside the settlement. And in there, the defense lawyer put a lot of emphasis on the fact that the quality of the plaintiff as a witness was part of the reason they paid what they paid. And so that was a material misrepresentation. It goes into what Pat was talking about, material representations and misrepresentations, and the case was set aside. As a general rule, if you look at the mediation application in Model Rule 4.1 that Pat discussed earlier, and you look in the comments section, it says, under generally accepted conventions and negotiations, certain types of statements are not taken as statements of material facts. This includes a statement of a party's intention to settle a claim. And the example they give is this, that if you're a defense attorney and you meet with your client ahead of time and you get authority, and they, we've all seen that where they've roundtabled the value of the case and they've kind of put a figure on it, and they know that they don't want to pay more than that amount of money. And now when the lawyer shows up at the mediation and the lawyer says, I doubt that the defendant is interested in settling this case. I think, me, the lawyer, I think this is a case that we can win at trial. That is puffery. That is acceptable. And that is right in comment sections of the model rules, that example. And I think that starts to kind of show us a little bit more of what is acceptable and what is not. The Verizee case relied on a case called Spaulding versus Zimmerman. And it's a case from 1962, the year I was born. It was a PI case, and a minor was involved in a car accident and had a crushing blow to his chest. The plaintiff's treating doctors treated him, and they felt that he had certain medical conditions. And then the defense sent the minor plaintiff for an exam. In that exam, the defense medical examiner found that, and it's an issue as to whether it was causally related or not, but that the minor had a aneurysm of the aorta. And now they go to mediation. And at the mediation, and in the plaintiff's brief, there's no mention of this aneurysm of the aorta. And the case settles for a lesser value than it would if it had this potentially life-threatening condition of the aneurysm of the aorta. case settles. 2 years later, the minor, no longer a minor, decides he wants to go to Vietnam, and he goes for a physical. And during the physical, they diagnose the aneurysm of the aorta. And the kid, isn't sure what that's all about. Well, now they go back and they find out that the defense attorney knew about it, the doctor knew about it, and they chose not to share that at mediation. And again, because it's hard to define puffery, a lot of times we look at when we don't disclose a material fact as a way to kind of, it's kind of the inverse puffery, if you will, but that's where a lot of the case law comes down. So you got to be really careful about, what you have to disclose and what the relevance of it is and how it pertains to your litigation. In advertising, we tend to look at, whether the fact is measurable, and we look at whether there was reliance. And I think that's a good framework to look at in mediation. In other words, we can think of some pretty clear examples that we see a lot in mediation. When somebody says, I'm not going to take a penny less than X, or I'm not going to pay a penny more than Y, and then they do. Now, are they puffing? Is that a misrepresentation? Did their thoughts change? And I think that's where we get into this dialogue, and where I'd like to open up a discussion for the four of us, which is, how do you deal with it? I mean, when I was a lawyer representing injured parties and corporations, I always wrote the brief and instructed my clerks to write briefs as if it was persuasive writing, using terms in the most favorable, but still being truthful and using puffery. And likewise, when I would read the defense briefs, I would say, they're putting their best possible spin on it. And I think it's our job as mediators to not only move the plaintiff off the first demand and the defendant off the first offer, but rather to use those briefs to try and figure out where that middle is, and where the puffery is kind of shaved away to get to the actual facts. So Glenn, where do you see this in both your mediation practice? Where do you see it in your actual practice? Oh, you're muted.
You're
Glenn.
muted, Jake.
I'm probably more interesting when I'm muted. Thanks, Jake, and thanks for the presentation. I think you raised some important issues strategically, including just keeping your credibility at a mediation. I think it's absolutely fine to puff, and I actually think it's easier to go up or down depending on whether you're the plaintiff or defendant than it is to go backwards. And so I don't get too worked up over high demands or offers. I'm just interested as to whether the case can settle. But again, your credibility is important. And so I think you need to keep in mind that the mediator is likely to go into the other side and convey what you're saying. And so you want to make sure you're sending the appropriate message, because if you puff too much and you have no credibility, then the other side may say, well, then we're wasting our time. We're not going to get anywhere, when in actuality, you have a lot more room to move and the case can be settled. There, I think it's the mediator's responsibility to get involved and make sure you're conveying the message that you want, so that it ultimately leads to a settlement, as opposed to something that's far too aggressive and the other side loses their credibility. So I think that's important. And then I'll just note, and I saw it in the chat line, and we're going to talk about the whole issue of mediation confidentiality. David's going to talk about the Cassell case, but it is interesting that with the mediation privilege, ultimately any misstatements in the voluntary mediation context probably don't ever see the light of day after the mediation. David, maybe we'll save that for your comments, but that's something we are going to talk about.
I have a
Go ahead, Pat.
yeah, I think that Stacy will probably cover this, but there's a real science in and psychology of mediation. And one thing that can tend to happen with puffery is that parties, once having made a statement, have a vested interest in sticking with that position and having to be talked out of it. Regrettably, if a party is puffing in front of their client in a mediation, they can create a dynamic where now they have to back off of a position they've taken, and it's very difficult to move the client away from it. The mediator has to step in at that point and try to help bringing reality to the situation. But puffery is, I think, the enemy of resolution because people tend to believe their own blarney, as we would say in Ireland.
Wait, Pat, you're from Ireland?
You know, I think that it's important that, you know, people maintain their credibility, as has been discussed by everybody. But at the same time, everyone knows it is a negotiation process. And I can't imagine people expecting that the opening demand or offer is going to settle the case. And either as a lawyer or a mediator, I think it's pretty well understood that you're not lying, you're hoping. And there's quite a big difference. We're talking about also the difference between an ethical violation, perhaps, and civil liability. And in a mediation, it would be one thing, I suppose, to ethically violate some rule by taking positions that are not well-founded and improper, but it's quite different to ask for too much or not ask for enough on either side of the case. I don't think it's anything more than the negotiation process, and the clients most likely have talked to the lawyer about it ahead of time and know that they're going to open with one figure and it's probably going to settle for a different figure. But it's of course true, as Pat said, and Stacy and Dottie will point out, that anyone who actually is tied to a position does create that kind of dissonance that's hard to break away from later.
Well, and I think that's where I would encourage people in brief writing, that the grandiose over-the-top statements that we see in advertising, and that I think this is what you're talking about, Pat, are going to work against you. But the unknown that you think may happen, it's okay to assert it, but then you got to be able to back it up. Glenn and I were talking the other day about, you know, the plaintiff, the injured plaintiff, who claims they're going to have a future surgery, and it's now been 3 years since the date of the incident, and they haven't had the future surgery. Now, the credibility of that plaintiff is going to ebb and flow based on the reasons why they haven't had that surgery. You know, can they make a good faith argument that they're not able to pay for the surgery, and if this case settles, they're going to have the surgery? Is that credible? Did they explore options through free or low cost healthcare and decide not to have the surgery because it was the risk of the surgery was high? What, you know, but that's an example, I think, of where we see puffery. And then on the other side, we see that too, where, you know, the defense medical exam may say, I think there's a chance that they're not going to have the future surgery. And then you kind of look at the facts, and then I think it's the job of the mediator to help them filter that out to try and determine, is that really part of this claim? We see that too with lost earnings. You know, it's one thing if your client worked at IBM, is out of work for a month, was making $1,000 a month, and you can quantify that loss. But when you have someone who's an entrepreneur, when you have someone who's a screenwriter, when you have someone who has a difficult lost earnings claim, you're going to see some, you know, puffery to see it in the most positive light on the plaintiff side. And then you're going to see the defense with a lot of statistics that it's never going to happen. And trying to figure out how to weigh those and balance those out, I think, is a big part of the settlement process and helps you kind of get to a number that makes sense for all the parties.
I was just going to add, I think Pat raises some points too, just that impact the overall strategy of mediation. And Some attorneys are real direct, and they have private conversations with the mediator as to where they're going to end up, and it's pretty close to exactly where they will end up at the end of the day. Other attorneys play very close to the chest and don't disclose that information. I was probably, when I was practicing, more along the lines of being direct and upfront and having a basis for that position. And I think in the end, it helped me get better results for my clients. But that's a strategic issue that I think you need to address. And as far as going too far with puffing, I think that's where you also want to make sure you have private conversations with your own clients and give them a heads up that, look, I'm going to argue this, but realistically, this is where we may end up. And we are going to talk about the ultimate settlement authority and who controls litigation this afternoon when we talk. And I think that's a point we'll cover then as well.
I think that's a great point, and I think it again ties into Pat's point, which is you don't want to be puffing in front of the mediator without already having had a meeting with your client to say, we're trying to get you the most money we can, but I don't think you're going to have that surgery, and so just because I say it, and so that's that gray zone, and I think that's where these rules on ethics are important to provide framework, but there is movement within those rules, and you gotta be careful not to go so far that it works to the detriment of your client on either side of a mediation. Anyone else want to talk more about that issue? We have a lot of these issues are going to tie into what we talk about this afternoon, which is going to be more of a broad general discussion on ethics and the mediation process, and it'll have more of a discussion element. And I think a lot of your questions that are popping up, we'll have a chance to review in between our two sessions, and we can try and address some of those. I do want to thank now the 1,200 people who have taken time out of their day to come onto this mediation and take time away from their practice. I'm guessing, given that there's an impeachment trial going on, or impeachment hearing, that the majority of you have a last name in the alphabet that is in the middle of the alphabet. Be sure and check when your hours are due and fill out all the forms that are required, because I think you have until February 1st to complete your hours. And if you stay on all day, you're going to get your 4 hours of ethics that you need. And I thank ADR for putting on this great program and giving people a chance for some free continuing education. I think it's very important to the practice of law in general. Pat.
Jake, yeah, you did mention something. I'm going to put on a little bit different hat.
Sure. I think that's why we have these discussions.
As former state bar president,
right.
That I think, carrying on what you just said, it's important to remember that the state bar really does look at whether you comply. And
right.
if you're one of the roughly 10% that gets audited and you come up short, you could face disciplinary activity because of that. So as we're talking about ethics, misrepresenting whether you've committed or completed your CLE falls squarely in the discipline column.
Right. People are signing that declaration under penalty of perjury when you represent the hours that you've had. And so whether you do it in the first 2 months of your 3-year period or the last 2 months, you got to do it. And I think it's a great point, Pat. And as I understand it, if they audit you and you don't have your proper documentation, you have a small time to cure, but then you're suspended, and it's a real serious penalty. Is that accurate?
Actually, I want to correct that. That's not the way it works.
Okay.
The
Yeah.
way it works is if you haven't completed it by the due date, by paying, I think it's $75, you can gain additional time to complete it. But once you've filed the declaration and you get audited, if you're found to be untruthful, it's a disciplinary offense, and people have been disciplined for that.
Right. I think if we're staying right on our schedule, it's time to transfer to our esteemed colleague, David Casselman. David's going to take some time to dive into a case that is near and dear to his heart, not only because it's the first part of his name, in the case is Cassel versus Superior Court, but because he was a participant in that case and not he was involved in it in a very impactful way. It's a Supreme Court decision that he was a party to, and he can offer some interesting insights into what happened and the impact of that on our daily mediation activities. David, why don't you set the stage for us? Tell us what the allegations were, the outcome, the history, the significance of that decision, and I'm sure we'll have some questions, as we move along.
Thanks, Jake, and thanks everyone for hanging in. We're almost done with the morning session. It's actually the Cassell case, and I'm Castleman, so thank goodness they're not pronounced the same. But having lived through this case, I have some thoughts about it. First, living through it as a lawyer and then as a party, I got some valuable perspective, certainly to draw on as a mediator. But I think most of all, it helped me understand what it's like to be in the shoes of all the participants in a mediated case. So let me start by focusing on the legal significance of the Cassell case, which was decided by the Supreme Court in 2011. But it's still recognized as important because it settled a key question about the scope of the statutorily created mediation confidentiality set forth in Evidence Code sections 115 to 1129. And it's important to read them because they are statutory. They're key provisions that have to be followed and understood. And 1119 was central to that decision and essentially provides that no evidence of anything that is said or admissions are made or anything for the purpose of or in the course of the mediation or a mediation consultation is admissible or subject to discovery in a civil proceeding. It doesn't apply to criminal proceedings, and there are exceptions, but the rule very closely follows the legislature, and that's the key, I think, to the case. The court provided an excellent overview of the prior judicial decisions interpreting the evidence code sections that created this mediation related confidentiality. And it protects against all these communications being used in subsequent evidentiary proceedings, absent certain steps, and they're set forth in Evidence Code 1123 within that grouping of mediation confidentiality cases, or statutes, I'm sorry. But following the statutory underpinning, the court always refers to this limitation as mediation confidentiality. You hear people refer to as the mediation privilege. To be technical, although it's very similar to a privilege like the attorney-client privilege set forth in the Evidence Code, section 954, it is technically inaccurate to refer to it as the mediation privilege because both the legislature and the courts call it mediation confidentiality. But the Cassell evolution itself, that is the case and the decision, can be simply summarized by its extension of the then existing law. And that is to say, it expressly recognized several key cases and reinforced their unanimous holding that the statutory provisions stating that mediation confidentiality applies extends not just to discussions during the mediation itself, but even to prior discussions between lawyer and client about the mediation. So it's not all communications at any point in time, but it is communications that relate to the mediation, whether during or before, and potentially after if the case hasn't already settled and the confidentiality continues. And the Evidence Code provides for when a mediation ends and how it ends. So I think the key point is there's a hard line. It's an absolute rule. No mediation related communications are admissible in evidence, even if fraud or alleged malpractice occurred. And so to reach that specific holding, the court was relying on section 1119 and specifically subsection C, which separates in the same sentence communications in the course of mediation from mediation consultations, holding both to be confidential. But getting past the holding, or to help maybe appreciate the holding a little more, let me share some of the underlying Cassell drama with you. And like every case, there were allegations and then there were defenses, and trials sort those things out. But the allegations that were made were that Cassell alleged that one of my former law partners failed to adequately represent him regarding a global master license dispute involving a clothing line. And he claimed my partner allowed his son to make internet sales of both licensed and unlicensed products, some genuine, some knockoff. And these clothes were governed, allegedly, at least by the Cassell license. He separately claimed that I promised him before the mediation in question that we would reject any settlement offer that failed to resolve the master license dispute under a certain fixed dollar amount. And then we allegedly failed to do that. And he also claimed that during the mediation, we starved him, we followed him around, we forced him against his will to stay until midnight, and then we compelled him to sign the settlement agreement for significantly less than he wanted, under the threat that my law firm would withdraw from the case, set to begin trial shortly thereafter if he didn't sign it. So our defense, we were handling the case as a firm. I had another partner responsible for the case. He was working on it with an associate. We were on an hourly basis. So the idea that we were operating with a financial incentive to settle rather than go to trial was backwards. In every way, the people who were in the office before I became involved believed that the Cassell case was a very weak position. The primary reason was his own conduct, and it was weakened further by what was perceived to be his demeanor, poor demeanor, and lack of credibility as a witness. As the head of litigation for the firm, I only got involved at the last minute at the request of the associate on the case because the partner was not available, and he was afraid we were going to lose a defense summary judgment motion. I got involved, I studied the file, I tried not to dabble, as Pat suggested shouldn't do. I read everything I could in very short order and got involved in the motion. We had to do some tap dancing and I had to appear at the hearing, but we did defeat the motion. So after it was denied, I sensed that the case could be settled. And so I reached out to the lawyers involved and told everybody literally as we were walking out of the courthouse and said, hey, don't you think it'd be a good idea for us to sit down and try and settle this case? We're set for trial and I'm going to try the case now if it's going to go forward. And I privately made it clear to our client that it was essential, especially for him, because we thought he was likely to lose the trial or certainly not win as much as he wanted. So for obvious reasons, our perspective was no one promised him or ever would promise him anything about what the offers might be or what we would reject, but he did make it clear what he wanted and we promised to do our best, pretty standard stuff. So as to my partner's son, our client knew about it. He was very happy making money from his internet sales for several years, never raised the issue until after everything was over and he filed suit. During the mediation, he was impatient, like many clients. He walked around a lot, wanted to leave, and we did our best to explain why he needed to stay, primarily because the mediator was working on the other side, and often for hours at a time. It was not an easy case to settle, and the other side, frankly, had a much better position and a tougher stance than we thought we were justified in presenting. So we talked late and we convinced him to stay late. We didn't want to stay till midnight, but we talked about the case, explained him all of our options. We offered him food of various kinds. We even had pizza delivered. He used complaints about food as an excuse to leave. And as anyone knows who's attended mediation, starvation is not, with food everywhere, the opposite is probably more likely a concern. So we urged him to stay, and particularly the mediator urged him to stay because he thought he had a chance to settle the case. And we all explained to him until we were blue in the face that We thought he had a tough road ahead of him and why we thought he did. And we were candid with him about that. So having agreed to clear my schedule to try his case, if no fair offers were made or accepted, we kept plowing ahead. And as the day wore on and the offers increased, we were doing well. And I was of the view the case really could and should settle. And I told him that. And ultimately, I became pretty frustrated by what I thought was a steadfast refusal to accept any offer. We were very close to the number, or fairly close to the number he wanted. Couldn't get there, but he wouldn't take it. And I explained to him that he had every right to reject the offer. But at the same time, I told him, look, I'm not going to drop everything else in my schedule to try a case that I think we're going to either lose or get less than what you're being offered. So I made sure that if he didn't want to take what I perceived to be their final fair offer, it was fine. But in that event, I would step out and the original trial team would step back in and handle it from there. Contrary to his claims in the case, the firm never threatened to withdraw. And after he signed the settlement, he was very happy because he got a 7-figure payout for a case we felt reasonably certain he could lose at trial. And we were pretty happy for him. And as we offered during the negotiations to help, we agreed to cut our hourly fees to make him happy, which we did. And although he claimed we didn't, we did, and refused, he said we refused to honor our word, and then he sued us. So that's the backstory that led to the litigation. So let me touch base a little bit on why we invoked the mediation confidentiality. And it was not an easy or even an obvious decision. And the reason, in talking to our counsel, which was excellent, and it's hard to be objective, even though we were experienced litigators, very easy to see as a party how it clouds your judgment. We wanted to try the case. We wanted to get the truth out. We thought we had nothing to hide. Our case was very easy to prove, multiple witnesses, fairly significant amount of documents that would prove that what he was claiming was just magical thinking at best. But it was significant to us that we had evidence from both pre-mediation meetings and the mediation itself. So if we asserted the confidentiality, we would be barred from offering a lot of our good evidence. And it was an issue. But we felt that his statements and all the documentary evidence far outweighed what we thought was an unsupportable claim. And we were incensed and thought we would win. Our lawyer convinced us that at what cost would we win? We would take a lot of time from our practice. We would be obviously compelled to appear in a number of ways. And that with the mediation confidentiality asserted and affirmed, we might avoid a trial in its entirety. We took advice, which I'm glad to say we did, even though it was still not an easy decision. And one of the final straws, I think, that convinced us to take it, as he pointed out, is that bad cases make bad law. And of course, we knew that, but without asserting mediation confidentiality, the case could potentially invite equally wild claims of mediation malpractice in other situations. And we decided we should assert the privilege and not try the case if we could avoid it. To my disappointment, after the Supreme Court decision, many of the same allegations were reasserted as if they occurred unrelated to mediation, and the case therefore went to trial. I testified at trial immediately after I was personally dismissed with prejudice. Soon after, the remainder of the case was settled for nuisance value, and that is the history of it. But I think in retrospect, it's important that although the case went to trial and the assertion of confidentiality didn't end it, it could have gone the other way, particularly with different players on the other side. I was quite surprised it did go to trial. But overall, we felt then and now that it was important to assert and therefore get a judicial confirmation of the confidentiality, which the trial court affirmed. The Court of Appeal did not. And reasonably, I think, the Court of Appeals said, look, why should this mediation confidentiality be allowed to protect lawyers who've done unscrupulous things, as alleged at least? And the attorney-client privilege is already waived in a malpractice case, so what's the point of asserting a mediation confidentiality in that context? There should be a built-in exception, a judicial exception. And the dissent said, well, but there isn't a room for a judicial exception based on the way the statute's written. Other cases had addressed that. And so the Supreme Court picked it up, I think, to clear any question about it and made it final that there is no room for a judicially created exception. It's an absolute rule. And I think it's important because, as the court felt, parties need to be free to fully avail themselves of the opportunity to mediate, rather than wasting additional time, expense, and risk of going to trial. So the alternative was to waive our rights and create that possible judicial precedent with a case that could go the wrong way. Lawyers are not liked by juries, etc. So in retrospect, while Cassell closed that door, I'm confident that very, very few, if any, legitimate claims actually involve malpractice leading to a mediated settlement, which is approved and then signed by the client.
Yeah, interesting. In retrospect, do you think it was a good decision to assert the mediation confidentiality in that case?
Well, as I said, I think it was a difficult choice, but particularly because of the position we held with not only our defenses, but the need to protect the confidentiality. On balance, we think it was the right thing.
Right.
David, as long as we're on the subject of Cassell type issues, when, in your view, does the confidentiality bar cease? When is it over?
Well, it's over if you're talking about something that is finally settled by the mediation with a written settlement agreement that, per the rules, expresses itself as binding. And that is what will also seal the confidentiality. If there's no settlement agreement, either on the record or otherwise, that makes it binding, it could be reopened without confidentiality. But I think the point of it is the parties to these cases are all dragged through. And I'm sure if Mr. Cassell was here or his lawyers, they would see it differently. And I'm not trying to suggest that this is a forum to relitigate it. The case went to trial and ultimately we effectively prevailed. But I think for a confidentiality situation, it's over when the mediation is settled properly and in writing. And that's the whole goal of going to mediation in the first place.
Yeah, David, I think that it's common now for mediators to follow up on cases that don't resolve, and that follow-up may be days, weeks, months, or even years after. And under your interpretation of the law and the law, that mediation privilege would still apply when I pick up the phone and call either the plaintiff's attorney or defense attorney or both, and we have discussions about the case.
Absolutely.
And David just mentioned the fact about whether the Supreme Court decision was correct. And as many of you know, a couple of years ago, there was really a big push. I did a lot of professional liability work, including legal malpractice. And there was a big push to carve out an exception legislatively so that in the malpractice setting, parties could raise what was discussed during mediation. And there was a very big pushback by counsel, and I think specifically even the plaintiff's bar, to make sure that did not go through. Ultimately, we got Senate Bill 954, which is a very watered down version of any sort of revision to the Cassell decision. And as of January 1, 2019, lawyers must advise clients that all communications between the lawyer and the client related to the mediation is confidential and cannot be admitted into evidence, even if the client later decides to sue the attorney for malpractice arising out of the attorney's conduct at mediation. And section 1119, and I believe 1129 of the evidence code was specifically revised, and you must have a printed signed disclosure. Technically, lawyers, and I know we started doing this when I was still practicing, are supposed to forward to their clients this form and have them sign it so that they're aware of the mediation confidentiality. In practice, I'm not sure how many lawyers actually do it. And we talked about this earlier briefly when we were talking about Puffery. Pat had mentioned B&P Code section 6068C, and which states an attorney cannot mislead a judicial officer. But interestingly, the old rule professional conduct 5-200B, misrepresentations to mediators are neither sanctionable nor subject to discipline. And in fact, the Foxgate versus Bramalea decision specifically held that a mediator can't reveal comments made during mediation, which were misrepresentations or potentially would normally be subject to discipline outside of the mediation process, again, because of that mediation privilege. So I think it's pretty clear in California that mediation privilege is strong and alive for all parties and the mediator.
Yes,
there are a couple of, I'm sorry, David.
Go ahead, Pat, sorry.
I think there are a couple of points that need to be made on this. The first applies often to a multi-party litigation, and that is, what do you do when you come back before the judge for a status conference in a high-stakes case and the judge says, you had a mediation, tell me what happened. Tell me what happened. How do you address that? The answer is, or the answer I've always believed to be, and the mediators I have worked with have said, is you can't. All you can tell the judge is the case settled or the case didn't settle. Period. The end. Does anybody disagree with that on the panel?
I used to say that Jake puffed too much and he made the case unsettlable. Was that wrong?
As a younger lawyer, I would get that a lot. And I always would say, under the mediation confidentiality, I can't talk about, and the judge would say, well, tell me the last offer and the last demand. I said, I can't, because you have to, you got to stand your ground.
One of the other issues that I think comes up is the question of whether it's actually a settlement conference. I defended, I used to do lawyers' errors and omissions cases a lot. I defended a law firm under circumstances similar to Cassell, David, where the plaintiff claimed the same types of things yours was claiming, kept up late, inadequate information, browbeat into a settlement, that sort of thing. And the question was whether that was admissible. In fact, the conference in which it occurred was a settlement conference in the Superior Court. So I'll throw that out to the group. Are you subject to any mediation confidentiality when you're in a settlement conference in the Superior Court?
Yeah, by the way, for those who are looking for the citation of Cassell, it's 51 Cal 4th 113, 2011 decision. 51 Cal 4th 113.
I have a question pending. I'll answer it if no one else wants to. The answer is settlement conferences are not protected under the mediation confidentiality requirements.
Yeah, I think
anything that goes on in a settlement conference can later be used as evidence in a case.
Right. And in some cases, you're going to have a case where the settlement officer with proper waivers may be your trial attorney.
That's true.
Rare, it's rare, but it happens.
So as far as the distinction, I think, between settlement conferences and mediations, the rules provide that it's not. Mediations are a separate animal, but I think that there was a question about communications after the mediation and whether or not it settles or not. there are a couple of questions about whether it will be confidential, with the confidentiality will apply later. And in part, it turns on whether or not the mediation itself has concluded. There's a specific set of rules that talk about, 10 days after, and whether it's concluded in writing and whether it's enforceable or not as per the terms of the agreement. But what are your thoughts, guys, about communications, for example, between the parties? Let's say the confidentiality has concluded, assuming it hasn't, I think the answer is easy, but assuming the confidentiality has concluded and there are emails or letters going back and forth talking about what happened, why the mediation failed.
I oftentimes have expert meetings which take place after a case that doesn't resolve because there needed to be a further exchange of information. And I'm oftentimes specifically asked to confirm that those discussions are part of the mediation process. And as far as my discussions and follow-ups, which frankly can go on months at a time before you get to a resolution, I think any conversation I have related to a case is mediation protected, and that's the position I would take until someone told me otherwise, because I'm really not just talking to them for my health. It's to try and get the case settled and continuing those discussions. But I think probably good practice for any attorney would be to confirm that this is all part of the mediation process and ongoing discussion so that there's no uncertainty for anyone.
Yes.
Glenn, I agree 100%. That's exactly what the practice is now, to have the mediator confirm with the other parties that the mediation is ongoing. The privilege still maintains until all those discussions are over. Because if you don't do that, a party can claim the mediation's over and the privilege is lapsed.
Another question was raised, which is again a good one, which is, would it be appropriate or valid for a judge during a mandatory settlement conference to get the parties to agree that the mediation confidentiality would apply to the settlement conference? I think it's a very good question. I haven't seen it, but I don't see any reason why they couldn't do it by agreement. Treat the conference as confidential for all purposes. You could do that even with a judge.
The question is then, David, though, what if a third person who was not a party to that agreement wants to obtain that information?
Well, that is a good question, but if the parties have treated it, expressly understanding that settlement conferences are not within mediation confidentiality, but they stipulate that it will be, and that the judge for that purpose alone can be treated as the mediator, I think it'd be an interesting question. I don't know the answer because I've never been tried, but I think it's a good question, and it's worth, if you're concerned about protecting the confidentiality, I don't see any reason why you couldn't try that and have a very important first gap defense if you wanted to use it.
Yeah, certainly I'd want to get that in writing and have signatures on that to try and support your position if that's where you're going with it.
Or on the record in the courtroom.
Yeah.
Okay.
I think we have a few minutes left, and I think Hayward's going to pop in perhaps with some questions in a minute. But Glenn, going back to your presentation earlier, you were talking about the benefit of having pen on paper when you resolve the case day of mediation. I think one of the benefits of Zoom is, there are many, but one of the problems with it is a lot of times that the plaintiff's lawyer and the plaintiff or the defense lawyer and their client are not in the same place. And I do think DocuSign is the future, because I think that would allow everybody to stay in the loop, and and I think that's where we're headed. I settled a case the other day where the plaintiff came to the plaintiff's lawyer's office, but were in different offices. And then whenever they were together, they were properly masked. So, but I think, DocuSign is the future on that. Hey, there's Hayward.
I've seen people actually take pictures of their signature because actual plaintiffs may not have a scanner
Right.
accessible to them or a fax machine or whatever, but they can receive an email typically through their phone. And then if DocuSign is not available, they will just print it out, at least sign it, and then send it back. I'm not aware of a case on that as to whether that'd be enforceable, but I think you'd have a pretty good argument that you've got a signed signature to it. And if nothing else, I think it would give an attorney a pretty good argument with their client that, look, you agreed to this, you signed this, and we can't back out of it now.
And that worked to the benefit of all parties.
Exactly.
And my question on that is, does that practice change because of the new CCP section that allows attorneys to sign settlement agreements?
That's a good question, Pat. Have you seen anything that's actually come out on that? I know there's specific statutes involved. In fact, was going to talk about that later this afternoon as far as who has ultimate settlement authority. But typically an attorney could not bind a party unless it's 100% covered by insurance, or there are specific exceptions, like in the construction context where it's being paid by a carrier. An attorney can sign it and it is binding. I'm not aware of any decisions or anything that's come out on that new CCP section. Have you?
No.
Just in response to a question from the panel, the code section that makes mediation confidentiality inapplicable to settlement conferences is evidence code 117B2, 1117 sub B2.
Perfect. I know a few of the questions were answered during the presentation, but I have a couple more that I'd like to ask the panel. First of which is more of a request to bear with me. So the question is, or the request is, can the panelists discuss a little further the idea when a mediation, quote unquote, concludes, and whether ongoing settlement discussions are covered by mediation privilege?
They are covered, and there's a express provision in the evidence code in the sections I gave you that establish when it's concluded. I'll get you the number in a second.
Okay. Perfect.
I agree with that. And I think it's a great way to keep the discussion open, and it's good practice for all mediators to follow through.
Yeah, and I think if there ever was an appellate decision on that, I think it'd be enforced because the court encourages settlement discussions and openness and resolution. And so I think even months after a settlement mediation rather, if there's ongoing discussions with the mediator or even among parties, I think it's going to be protected pursuant to that evidence code section.
1125.
Okay.
Dave, that's evidence code section?
Yes, it is.
Thanks.
An interesting question. In Reading, the court will not accept documents without a physical signature. How do you handle the clerk rejecting documents that are not actually signed in these COVID days?
It's Reading County.
Did not specify.
Yeah.
I personally haven't run up against that. Even if you were to get a picture or a DocuSign, there's still no reason that you couldn't have a hard signature a couple days later through mail, and probably best to follow up on that and get that for your files. But it's hard to believe, as the courts are certainly leaning on attorneys to work with each other and be civil and cooperate. And I think that makes sense in these crazy days. I don't know why the court can't work with the parties to accept a non-physical signature, but that's probably why I'm mediating now instead of going to court every day.
No, Glenn, I'll go a step further. I would have to research that. I've not directly had the issue, but I seem to recall that there is a rule that provides that duplicate exemplar types of signatures are usable, particularly during this time of COVID-19. So
Well,
I'm not sure the court even has the power to set forth that kind of a rule.
well, you know, they come in all the time in real estate matters because DocuSign is used routinely to establish agreements involving the transfer of real estate, which are very carefully restricted if you don't have a writing. So I would think that it should come in too, but if you really are concerned about it, particularly in a jurisdiction where you think that might come up, probably include a clause in the agreement that says the parties hereby agree that this document shall be admissible into evidence pursuant to stipulation by a DocuSign signature. And that should help you in the courtroom.
Either that or don't file in Reading.
And I gave Reading credit for being its own county. Apparently Reading is part of Shasta County. And I'm not sure I understand the complete question, the hypothetical, but if it's, the court was requiring a signature for a plaintiff to show that the case had been resolved, you know, there might be a way to deal that with the lawyer filing a notice of settlement that the lawyer can sign. But I don't quite understand the full ramifications of what they're asking.
Perfect. Well, we're going to conclude the morning session here. Thank you, presenters, and thank you all for joining us this morning.